Welcome everybody, or welcome back if you attended our reading upstairs. I'm Brad Sears, the Executive Director of the Williams Project, and we are now going to start the 5th annual update on sexual orientation law and public policy.
We began to try to imagine what the world would look like if we could help establish that there was something wrong, something constitutionally wrong with government policies such as any sexual act involving the sex organs of one person and the mouth or anus of another is a felony punishable by up to 20 years in prison. Or homosexuality or advocacy or encouragement thereof shall be considered cause for removal from employment as a teacher in a public school. Or marriage shall be limited to a relationship between a man and a woman. Or no state shall be required to recognize or give full faith and credit to a same-sex marriage deemed legal in another state. Or a gay partner of the biological parent of a child shall not be entitled to visitation rights upon the couple's separation. It is in the best interests of a child to be placed with her grandmother, not her mother and her female partner. Or social welfare agencies shall not consider any homosexual person or same-sex couple eligible for any placement of a child for foster care or adoption. Or homosexual conduct, including statements that one is gay or lesbian, unless one can rebut the inference therefrom of a propensity to engage in homosexual conduct, shall be a basis for separation from the United States Armed Services. Now, back 25 years ago, thinking of a theory to challenge these forms of discrimination was a little bit like the Pirandello play, 6 Characters in Search of an Author. Was it a privacy right? An equal protection right, a free speech right? Take the box, no, take the curtain. Well, let's start out with privacy. Was the right to privacy focused on sex acts? Well, obviously the sodomy laws were a first avenue of legal challenge. But to focus on the sodomy laws seemed to focus on just a portion of what was precious and protectable in our lives. The older you get, you realize it's maybe even less central and protectable. And to play into, the other fear was that it was to play into the demeaning sexualized stereotypes of gay men and lesbians that those of us who were too busy assimilating and covering were eager to refute. Of course, it still seemed outrageous that sodomy was a crime punishable by 20 years in prison in half the states, and a legal anomaly that while there was a right to contraception and abortion in the name of privacy, there was no right to privacy that actually extended to sexual activity itself. No right to be presumptively free of governmental intrusion into our bedrooms or our most intimate lives, even for consensual, adult, non-commercial acts of lovemaking. Abortion is a difficult issue. This one, we thought, should have been easy. So we pursued privacy theories, but there was also the question, was it an equal protection right? Was it a right against discrimination based on irrelevant and phobic prejudice analogous to that which had been recognized as an invalid reason for laws based on race or sex? There was no notion then that the anti-discrimination principles that had been applied to race or sex or to alienage or non-marital children could be extended to sexual orientation. Now, a few justices on the Supreme Court gave faint glimmers of recognition to this possibility. Let me take you back, for example, to the Rowland versus Mad River School District case in 1985, a case involving the firing of a lesbian public school teacher. She challenged it on a variety of grounds, lost in the circuit courts, took it up on a cert petition. Cert was denied, but Justice Brennan, writing for himself and Justice Marshall, dissented from the denial of cert. And in that, you have to think this is the time when the sex discrimination cases are just beginning to be fashioned. Bakke it was still recent law. From Justice Brennan, he said the following. He said, homosexuals constitute a significant and insular minority of this country's population. Because of the immediate and severe opprobrium often manifested against homosexuals once so identified publicly, members of this group are particularly powerless to pursue their rights openly in the political arena. Moreover, homosexuals have historically been the object of pernicious and sustained hostility, and it is fair to say that discrimination against homosexuals is likely to reflect deep-seated prejudice rather than rationality. That's Justice Brennan dissenting from Rowland in 1985. Not bad for a devout Roman Catholic Irish leprechaun from New Jersey, right? And one whose own living memory could recall the signs saying no Irish need apply. So he understood about minorities who were perhaps able to assimilate but not quite pass. But he couldn't get more than one justice at the time to agree with him. What's more, the equal protection theory created a little bit of paradigm confusion. Theoretically, as Yale law professor Bruce Ackerman pointed out in a wonderful article called Beyond Caroline Products, said, well, gay people are really not a discrete and insular minority. That paradigm of racially segregated minority groups that had occupied our attention in equal protection law since the famous Caroline footnote Products 4, said Ackerman, gay people are really a diffuse and anonymous minority, not a discrete and insular one. Didn't mean there should be any less judicial solicitude, because as Justice Brennan said, being diffuse and anonymous is a form of political disempowerment, just like being discrete and insular is. But apart from the theoretical problem, there was pushback from some members of traditional civil rights advocacy groups, some of whom bristled at what they perceived as gay and lesbian free riders on a long, hard struggle to disassociate law from race, and who protested that the regulation of gay conduct was a far cry from the auction block on which human beings were bought and sold as chattel. Well, we argued back, of course, that discrimination takes many forms. Diffuse and anonymous minorities are as politically disabled and in need of judicial solicitude as discrete and insular minorities. And the Supreme Court, in recognizing a constitutional right against sex discrimination, had extended the Equal Protection Clause from the auction block to the pedestal on which, as Justice Brennan said, and as Professor Yoshino referred to earlier, the pedestal on which women had been placed, but which so often became a cage. We thought it was just one more step along that continuum to extend the metaphor from cage to closet, and to declare sexual orientation discrimination also suspect. Well, privacy, equal protection. Third character in search of an author, third theory in search of a court, was the First Amendment freedom of speech. After all, the closet was forced silence and anonymity, the taboo on discussing gay issues a classic suppression of dissent, of sexual dissent, and such viewpoint discrimination and silencing normally trigger serious First Amendment concern. Indeed, one of the first gay rights cases I worked on in 1984 with Professor Lawrence Tribe, as Professor Rubenstein referred to, involved a challenge to an Oklahoma law providing that public school teachers would be fired for teaching that, quote, advocates, encourages, or promotes homosexual activity. Now think about how vague and broad and chilling that is, right? There goes Willa Cather and Oscar Wilde from the 11th grade English classes, not to mention an end to the Socratic method. Now, anything could be suspected of putting gay people into encouraging a light. Now, this was a policy so odious that even Ronald Reagan had opposed it when it arose on a ballot initiative here while he was governor of California. I had the privilege of working with my great mentor and professor at Lawrence Tribe and the Oklahoma ACLU on this case. The Oklahoma ACLU, a small but hardy organization. And we challenged this restriction on public school teachers as impermissible viewpoint discrimination in violation of the First Amendment protection of freedom of speech. Our side prevailed in the 10th Circuit, and the United States Supreme Court affirmed by an equally divided vote. It was 4-4 because Justice Lewis Powell happened to be ill and at the Mayo Clinic during that sitting. A lucky break for us in Oklahoma City that proved prophetic of the doom we would later suffer before the same court 2 years later in Bowers versus Hardwick. Of that more in a moment. Now, in the Oklahoma City case, we glimpsed a fourth theory of why gay rights might be constitutionally protected. I want to share this with you today. One of our legal team, a terrific gentleman named Bill Rogers of the Oklahoma ACLU, came into a meeting one day and said, I've had an epiphany. I now know the answer. Forget about equal protection, forget about privacy, forget about freedom of speech. I have a better answer. I've thought about it and I've got the constitutional theory. And we all said, Bill, what is it? He said, we declare homosexuality a religion. Then we litigate for our right of free exercise of religion, and we challenge compulsory heterosexuality as an unconstitutional establishment. And let's face it, it made a certain amount of sense. After all, gay men and lesbians have our rituals, our creeds, incantations, and special ways of dressing. Why not? Well, for obvious reasons, this didn't seem like a political starter. And then came Bowers versus Hardwick, a case whose facts seem difficult to believe in retrospect. This guy walks into a bar. And he says, Michael Hardwick, here's a warrant for your arrest. No, Michael Hardwick, long since left us, gorgeous, Adonis, peaceful bartender at a gay bar in Atlanta, was arrested in his home by an officer serving a warrant for his failure to appear for a ticket for public drinking. The officer had spent a lot of time outside that bar looking for people who might be cited for public drinking, and Michael opened up a beer in a brown paper wrapper after his shift at 2 a.m. The officer was let into the house that night by an overnight guest, so no Fourth Amendment problem, and claimed to have seen Hardwick and a consenting lover in flagrante having oral sex in the privacy of Michael Hardwick's own bedroom. And the Georgia ACLU saw this as the potential test case that could finally bring down the sodomy laws. They're not often enforced. This was the test case from central casting, a police officer actually in the sacred precincts of the bedroom, to quote Justice Douglas in Griswold. Well, there was also the thought that with the long prospect of Republican presidencies, the last best chance might be to get somebody like Lewis Powell to provide the fifth vote for such a right. After all, he'd provided one for other privacy rights, was sympathetic to grandmothers living in extended families with their grandchildren, for example. Well, victory in the 11th Circuit. This time, Larry Tribe and I had the privilege of working with the Georgia ACLU to challenge the Georgia sodomy laws, a violation of that same implied right of privacy that had protected rights of family formation, marriage, contraception, and abortion. We went up to the Supreme Court with the positive decision from the 11th Circuit, which the same brave judges that had desegregated the Jim Crow South had held that there was at least a quasi-suspect or a quasi-fundamental right cast to a sodomy law, and there was at least a quasi-fundamental right to have consensual, non-commercial sex with an adult partner in the privacy of your own bedroom. Said the Supreme Court, no, in a bitterly divided 5-4 decision in which the late Justice White wrote for the court that our argument that, this was our argument, as he characterized it, our argument that a right to engage in homosexual sodomy is deeply rooted in this nation's history and tradition, or implicit in the concept of ordered liberty, is, at best, facetious. Now, I have to tell you that my very first case I worked on with Larry Tribe as a third-year law student, we'd represented the Hare Krishna who were trying to proselytize at the Minnesota State Fair and were confined to a booth, and we said that confining them to a booth was not a time, place, and manner restriction. It was really a discrimination against unpopular people because, hey, if you're Hare Krishna, who's going to come to your booth, right? You go to the Methodists, you go to the Episcopalians, you're in saffron, you've got these cymbals clanging, it's going to be a long, very hot day at the fair. So we said this is de facto discrimination against unpopular groups. Justice White, writing for the court, rejected that theory, and he wrote in a footnote that the theory was interesting but has little force. And I was devastated at the time. We get Bowers versus Hardwick. He says our theory is at best facetious. I said to Larry, I long for the days of interesting but little force. Now, a beautiful dissent by Justice Blackmun said that this was not a case about homosexual sodomy, as White had put it, but instead the most comprehensive of rights and the right most valued by civilized man, namely the right to be let alone. Only the most willful blindness, said Justice Blackmun, could obscure the fact that sexual intimacy is a sensitive, key relationship of human existence. The fact that individuals define themselves in a significant way through their intimate sexual relationships with others suggests, said Blackmun, in a nation as diverse as ours, that there may be many right ways of conducting those relationships, and that much of the richness of a relationship will come from the freedom an individual has to choose the form and nature of those intensely personal bonds. Now, the deciding vote was Lewis Powell's, who'd been missing in the Oklahoma City case. The story is now familiar. He went our way at the conference on Friday after the Wednesday argument, but changed his mind over the weekend, reflecting that he perhaps didn't want to go with the idea that there was an implicit right in the Constitution to homosexual sodomy. And he told Harry Blackmun that summer, as they all went off to Europe for their summer teaching and speaking engagements that, Harry, I just never met a homosexual. Not knowing that one of his law clerks that year was gay, not knowing that others of his favorite law clerks were gay too. Justice Powell later told an audience at NYU, moot court by students who said, did you ever make any mistakes while on the court? You know, that's like that question to Eisenhower, did you ever make any mistakes? He said, yeah, 2 of them, they're both sitting on the Supreme Court, Warren and Brennan. Did you ever make any mistakes while you were Justice Powell? And Justice Powell said to that NYU audience that he thought his vote in Hardwick may have been a mistake, because he cast the 5th vote to go with White's opinion rather than Blackmun's, because he later read the dissent and thought it had the better of the argument. So 17 years later, in June 2003, in a 6-3 decision by Justice Anthony Kennedy, and this is why we should take Supreme Court justices from California, the Supreme Court invalidated a same-sex sodomy law out of Texas, declaring Bowers versus Hardwick overruled. Now, I just want to say a few things about that 17 years. Okay? First off, that's a long time. Technology had changed. We wrote Bowers pretty much almost on a typewriter, and I read this decision with tears streaming down my face onto my keyboard of my laptop, you know. Who could have imagined that we would have such technology in that time? And I really don't like this passage of time thing. I still take F3rd personally, the idea that we're in F3rd. But a lot of things have changed. You might say, well, what was so bad? Were there that many sodomy prosecutions? Well, not so many, but how many custody cases lost? How many people fired from public jobs? How many people closeted and culturally imprisoned by the legitimacy the sodomy laws gave other forms of discrimination? And Anthony Kennedy got that. And in this 6-3 decision, O'Connor joined. She didn't overrule herself in Hardwick, but came in on an equal protection ground. I want to read some passages from the Kennedy opinion as the lead into my close. Kennedy writes, Bowers versus Hardwick does not withstand careful analysis. Bowers was not correct when it was decided, and it is not correct today. I have to tell you, as a casebook author, it was so much fun turning Bowers into a note case and making Lawrence versus Texas the principal case. That was so much fun. Bowers does not withstand careful analysis. Bowers was not correct when it was decided, and it is not correct today. And he essentially took our brief in Bowers, our losing brief in Bowers, and wrote it into U.S. reports. I read on in Justice Kennedy's words, the present case does not involve minors. It does not involve persons who might be injured or coerced or who are situated in relationships where consent might not be easily refused. It does not involve public conduct or prostitution. Now, there he's reciting the litany of the parade of horribles. If we strike down a sodomy law, we have to strike down all vice crimes. And we had practiced many answers before the oral argument. I had rehearsed Larry Tribe on the reasons why all of these other crimes implicated either state interests or interest in prevention of material harms that the sodomy laws didn't prevent. But we were always worried about incest. And there was this moment in the case where Tribe was giving our argument where he said that incest laws protect people against the possibility of coercion that you might not be able to get at directly in parent-child relationships. And Chief Justice Berger, who had a habit of having his head slipped down onto his chest into apparent slumber during the argument, popped up and said, "What about brother-sister incest?" It was a startling moment in the oral argument, I have to tell you. But what we're trying to do here is to say that apart from fornication laws and sodomy laws, there was at least a colorable state interest behind these other laws, prostitution and so forth. And Kennedy here is saying this case is not like those cases. That was profound. Then he goes on to say, Justice Kennedy's words again, it does not involve whether the government must give formal recognition to any relationship that homosexual persons seek to enter. Okay, so we don't like that sentence so much. Then he says the case does involve 2 adults who, with full and mutual consent from each other, engaged in sexual practices common to a homosexual lifestyle. Okay, so we don't like the lifestyle line so much, but the point is good. And let me just keep reading so we get the point. The petitioners are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. Their right to liberty under the Due Process Clause gives them the full right to engage in their conduct without intervention of the government. It is a promise of the Constitution that there is a realm of personal liberty which government may not enter. The Texas statute furthers no legitimate state interest which can justify its intrusion into the personal and private life of the individual. And then listen to this. He takes us back to the founding, and he says, had those who drew and ratified the due process clauses of the Fifth Amendment and the 14th Amendment known the components of liberty in its manifold possibilities, they might have been more specific. They did not presume to have this insight. They knew that times can blind us to certain truths, and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. Now, buried in those somewhat thrilling words, and for those of us who remember the 80s, that was an astonishing thing to read in U.S. reports. Buried in there is not just a thrilling outcome, but an answer to the question about 6 characters in search of an author, 6 theories in search of a court. And the point is this. It's that no one theory is sufficient to explain Justice Kennedy's opinion for the court in Lawrence. It's not just a privacy opinion. It's not just an equal protection opinion. And it's not just a recognition that gay law, now part of the Constitution after all, is a law that does dare speak its name, not just a First Amendment case. What Lawrence affirmed is also a bigger, broader theory that I want to leave you with the thought today is actually a fundamental part of American constitutional law writ large. And again, taking a piece from Kenji's earlier talk, you might call it the American constitutional right to flourish. Now, let me explain what I mean by this. What is so brilliant about Kennedy's Lawrence opinion is that it shows that liberty, equality, and free expression cannot be entirely disentangled. That to free people from subordination by law is, at the same time, to enable them to express themselves more fluidly, both as individuals and as members of intimate and expressive associations. Now, some critics think that some aspects of gay litigation strategies have been too reifying of this entity called gay men and lesbians, or gay men and transgender people, or homosexuals. That as a gay person is not a good strategy because it just reinforces the very discrimination it's supposed to undermine. But I want to say I don't think that's right. To liberate people from sexual orientation discrimination is not to reinstate some rigid category of homosexuality in a Kraft-Ebing sense. Other critics think that gay law is too mainstreaming, that somehow to want all this assimilation into the Constitution as into the society is the wrong strategy. It gives up a precious right to difference and revolution. But the elimination of sexual orientation discrimination need not touch off a march of lockstep lambda lemmings toward the sea of assimilation into the mainstream. Nothing in any anti-discrimination law would make gay marriage compulsory. It would merely be made available as a choice. Now, if we take a fluid view of what American constitutional law is all about, a fluid view that it's about enabling us to individually interact with people and groups as we please, we see that those interactions can work both ways. Who knows whether marriage would change gay people, or gay marriage, who knows whether gay marriage would change gay people, or gay marriage change marriage? Or if you don't like that formulation, think of the way Roseanne put it, that famous legal philosopher Roseanne, who said, when she was first asked, what do you think about don't ask, don't tell, she says, I wish the entire military were run by gay men. There'd be no more wars and a lot more attention to military apparel. Now, protecting the fluidity of sexuality and sexual expression from state prescription and state proscription is, I want to argue to you, along with federalism, free speech, freedom of religion, freedom of association, and a host of other aspects of American constitutional law from no titles of nobility on down, a classic part of American constitutional law, which depends upon the view that unlike Belgrade, Belfast, or Beirut, Americans are not segregated into separate, siloed, and totalizing identities, but free to move as individuals to groups and groups and groups, as well as from them. Gay law is part of what Professor Anthony Appiah calls cosmopolitanization, the recognition that we put together a complex and overlapping set of identities over our lives, And I say to you, that is what the Constitution deems freedom. Now, we sit here, those of us who are older, with those of us who are younger, students here at UCLA, benefiting from the Williams Institute, and you are the generations, you young people in the room, you are the generations that Justice Kennedy was talking about. There'll be changes in your lives, too. You're the ones that the Williams Institute will help to educate and to vindicate. You're the generation that has witnessed the amazing sight of celebration in San Francisco as gay marriages took place in City Hall. And citizens, gay and straight, said, "Isn't it festive? Isn't it wonderful?" You're the generation that has recognized that many of the men and women in uniform on whom national defense depends are gay. You're the generation that doesn't quite understand what the fuss is all about. What? You never heard of the chalk circle. You didn't know that the Hollywood rule that the lesbian has to die at the end of the movie. You tune into the L word. You're used to seeing gay people on Friends and Ellen and even The Simpsons. And there is a cultural change that, of course, always goes hand in hand with any legal change and often marches in its vanguard, a cultural change that is irreversible. There is much in the legal struggle that I've described that has gained from will and grace. But this afternoon, I'd like to just remind us that there's another kind of will and grace we have to thank, not the TV show, but the will of lawyers and the grace of judges, a grace that, as Justice Kennedy's opinion in Lawrence demonstrates, is a grace that can sometimes amaze. Thank you very much.